Hello everyone, my name is Giovanni Nogales and I'm a paralegal here at Lyle Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Improper Home Health and Hospice Marketing Practices Seen in Texas. Are your marketing practices consistent with the anti-kickback status safe harbor requirements? Today's presenters are Ashley Morgan and John Pierce. John Pearson is an experienced former federal prosecutor and trial attorney whose practice focuses on sophisticated criminal defense and civil litigations. His background is rather unique. Prior to entering private practice, Mr. Pierce served as an assistant U.S. attorney in the Southern District of California, the District of Columbia, and the Eastern District of Virginia. While working as a federal prosecutor in the Eastern District of Virginia, he represented the office on the Attorney General Advisory Committee for the healthcare fraud. Since he's leaving the government, Mr. Pierce has successfully represented both foreign and domestic individuals and corporations in healthcare, commercial securities, corruption, export controls, and tax disputes. He has also handled several whistleblower cases. As for Ashley Morgan, is a partner in Lyle Parker's DC office. Ashley focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ms. Morgan represents healthcare providers across the country in connection with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board compliance, and exclusion and termination issues. She has worked with an assortment of providers, including home health companies and hospice agencies. Ms. Morgan is also a certified professional coder, a certified medical reimbursement specialist, and a certified medical compliance officer. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we'll address as many as possible at the end of the presentation. So without further ado, I present your speakers, Ashley Morgan and John Pierce.
Thank you, Gio, and thank you all for joining us today. We can go ahead and go on to the next slide. Just a brief disclaimer. This outline is presentation today is being provided as general information only. It does not constitute legal advice and should not be used as a substitute for seeking legal counsel. While we are attorneys, we are not your attorneys, and outcomes in cases vary dramatically based on specific facts. Next slide. So this is just an overview of what we're going to be talking about today. We're going to talk about some types of relationships that create risk, some of the applicable laws in regard to marketing practices, and that could, have you have liability. Some interpretive guidance from HHS and OIG, and then some suggestions on crafting compliant agreements to keep your marketing practices compliant. Next slide. John, do you want to talk about some of the problematic practices?
Sure. Thank you, Ashley. When it comes to physicians, frequently we represent people who have entered into directorships, and the authorities find that they don't comply with what is necessary. So when we consult with somebody and the issue relates to somebody that's a medical director, what we need to inquire about is, whether the services are arm's length and paid based on the services provided and not based on referrals. In other words, there cannot be a medical director relationship that is based on volume or value of referrals. We're going to hear that a lot today, volume and value. For marketers, if they are paid in excess of market value, if there are gifts to either the patients or the sources of referrals or that sort of thing, then again, that's going to bring them under this microscope of authorities. And that also is based on value and volume. There can't be a tie on referrals to marketers based on value or volume. Next slide. Ashley?
Yeah, so another area where we see problems is with facilities like nursing facilities, for example. If a home health or hospice company wants to have an agreement with a nursing home to lease space, for example, those agreements, they need to meet specific safe harbor qualifications to ensure that they are compliant. Some problems that we see are that the agreement is specifically discussing sending patients to the home health or hospice agency for care, or having the home health or hospice agency come in and treat the patients, if that's just a nursing home, or if it's a skilled nursing facility, you know, to send the patient to the home health or hospice when they're discharged. Excessive rent, if we're talking about leasing space, that can be a problem with the Anti-Kickback Statute. Free or below market value services that are being provided by the hospice, for example, to the nursing home, referring a home health or hospice patient to a nursing home in exchange for the nursing home referring hospice patients, and the agency going through the medical records of a skilled nursing facility or assisted living facility to essentially look for possible referrals without specific patient permission. That's a big no-no, not something we can do. We can't just look through patient lists to find potential patients. So those are just some examples that we see in example cases that come out in press releases to be aware of, and problematic practices that you want to avoid. Next slide. Okay, so we're gonna just give some examples here through a case study with a couple cases that took place. This one here took place in Texas. Some of you may be familiar with this case. It was pretty well publicized when it happened. This is the Jacques Roy case, U.S. versus Jacques Roy, and it was related to Jacques Roy and home health agency owners as well. Dr. Roy had over 11,000 patients and was affiliated with 500 home health, home health agencies in Texas. These home health agencies would refer patients to Dr. Roy, who would then, of course, refer them back to the home health agency. This physician had referral agreements with multiple home health agencies throughout the state. Home health agency personnel were driving around Dallas homeless shelters, offering food stamps to individuals or to buy groceries. One home health owner paid recruiters $50 and offered to buy homeless patients McDonald's. Another home health agency went door to door looking for Medicare beneficiaries, you know, just knocking on the door, asking if people were Medicare beneficiaries to essentially find potential referrals. Some home health agencies that were involved in this investigation had over 80% of their patients being referred by Dr. Roy specifically. And Dr. Roy's office was handling more home health visits than any other physician's office in the country. With this volume, he had his employees fraudulently sign his names to plans of care and home health certifications, which we know is a big no-no. We cannot have fraudulent signatures. He's not seeing these patients. He can't be signing for the services or having somebody else affix the signature to the plans of care or to the certifications. In this investigation, the government used data analytics to identify the fraud. You know, one thing that the government is always very good at is collecting data about providers. And if you have one doctor who's signing plans of care and certifications for hundreds of home health agencies, that can have a major red flag that they need to, take a look at the records, see what's going on there. The OIG said that most physicians refer fewer than 100 patients for home health. So you can see that's a dramatic difference here, that he had, 11,000 patients and most physicians are referring fewer than 100 patients. When Dr. Roy's first practice was suspended, he created a second practice, which paid significant management fees to the original practice. So he got in trouble and then had a workaround to continue to defraud the system. He was ultimately sentenced to 35 years, and other individuals who were involved were sentenced for time anywhere from 3 to 17 and a half years. Dr. Roy agreed to pay $268 million in restitution. So this is a pretty egregious example, but it's very important that we're careful about our referral arrangements and how we are getting our Medicare beneficiary patients, because that information all goes to the government, and they're very good at reviewing that documentation, seeing where patients are coming from, and conducting these investigations to ferret out fraud. And it's a very big interest area for the government. Next slide.
And Ashley, if I could just speak for a moment to the data analytics. The government calls those outliers when they see somebody whose data result, when they run a data inquiry, is so far outside the rest of the market. So it doesn't matter if they're looking at a certain billing code and see that, you know, one provider is using it much more than any others in a region, or whether it's, you know, the numbers of referrals from a particular doctor. But just understand that everything with the government and to start an investigation is data driven. So you can't hide from the numbers. So if the data is going to be outside what the government's used to seeing, it's going to trigger a red flag.
That's right. Thank you, John. The next case that we have here, this case was out of Missouri. It was U.S. ex-rel Cordingley versus Good Shepherd Hospice. This case was a PTAM, a whistleblower case, which essentially means that an individual brought a False Claims Act investigation, a False Claims Act case, you know, and then the government intervened and took on the case, but a whistleblower notified them about the concerns under the False Claims Act. Good Shepherd was based in Oklahoma City and provided services in Oklahoma, Texas, Missouri, and Kansas, and had 15 offices. The whistleblower in this case was the executive director for one of the offices for only a 6-month period. So, you know, it's important to note, you know, it doesn't take too much time for somebody to come in and see problematic practices going on. So you need to make sure, you know, if somebody notifies you about a concern, even if they're a rather new employee, that's something you need to take seriously. Because a lot of times a whistleblower is an individual who, you know, notifies the agency about their concerns and feels like the agency is just disregarding those concerns. So this individual, you know, was only there for 6 months, and you know, decided that the agency needed to be reported. This hospice was hiring medical directors based on their ability to refer patients, and was focusing on medical directors with ties to nursing homes. The hospice had 4 to 5 medical directors who each worked only 2 hours a month, but received about $3,000 in salary monthly. So again, that kind of goes to the fair market value for the services that these individuals are providing. You know, that's a lot of money for 2 hours a month. The hospice was requiring medical directors to refer 1 patient a month. One medical director was terminated for failing to bring in referrals, and he subsequently expressed concern about the quality of care as a reason for not referring patients. The hospice would keep at least 1 patient in a nursing home as a hospice patient, so that they would have access to continue to market their services at that hospice. So they, you know, they would just try to continue these relationships so that they can continue their marketing practices in these nursing homes, even if a patient didn't necessarily qualify for services anymore. And then we have a couple more points on the next slide about this case. Thank you. The hospice nurses were also performing the work of nursing home nurses when in the facility treating hospice patients. You know, there was a quote that we have here: "If you give me 5 patients, I'll put a nurse's aide in your building all day long." They were also providing expensive Broda chairs free of charge to the nursing homes. The hospice was also paying for residents' room and board, even if it did not receive Medicare payment due to faulty paperwork, which can be, you know, that's a kickback violation. Hospice consultants, which were actually marketers, were giving nursing home staff gift baskets and free lunches to achieve their quota of 5 admissions per month. And this case ultimately resulted in a settlement for $4 million to be paid back. And Good Shepherd was required to enter into a 5-year corporate integrity agreement. And generally, corporate integrity agreements, they can have a bunch of different provisions, but a lot of times they require pretty intensive compliance reviews for an extended period of time, and can be very onerous on the part of the agency. So again, you need to make sure if you're working with nursing homes or receiving referrals from nursing homes or renting space, that all of those agreements and marketing practices are in fact compliant. Next slide. Okay, this case is U.S. versus DeBoer and Whitaker, and this came out of Texas as well in 2018. John DeBoer was a registered nurse, and he owned Care Communities Health Services. DeBoer and Whitaker were paying group homeowners for access to and for referring Medicare beneficiaries for up to $500 for an initial certification and $250 for a recertification. Payments were made both in cash and by check. DeBoer was paying marketers and recruiters, including Whitaker, to find beneficiaries. Beneficiaries were being paid to sign blank home health forms. Big no-no. You can't pay a beneficiary to sign a home health form. DeBoer was found guilty after a 4-day jury trial and sentenced to 9 years in prison and required to pay $3.5 million in restitution. So again, you cannot be paying for referrals, paying for specific amounts based on the volume or value for certifications and recertifications. And again, I think probably everybody on this call knows you cannot, provide reimbursement to a Medicare beneficiary to sign up for services. Next slide. Okay, and now we're going to go over some of the applicable laws for marketing practices. Next slide. Healthcare spending has come under increased scrutiny, which has spurred increased regulatory enforcement efforts for both state and federal healthcare programs. Statutory requirements for the Anti-Kickback Statute and for Stark and for the False Claims Act, they can be very complex. These laws change regularly as well. Non-compliance can result in criminal charges, civil sanctions, and/or civil monetary penalties. It's important that you stay abreast of what the requirements are and that you engage, with experienced healthcare counsel when you're entering into different marketing agreements. A failure to comply with applicable healthcare laws and regulations can expose an agency, its leadership, and its owners to extensive civil liability. I will say something that we've seen in cases is the government wanting to hold individuals accountable, individual owners accountable, in addition to the agencies themselves, the corporations, because they kind of take the position that there are individuals who are operating these agencies who should also be held accountable. Next slide. Some trends that we are seeing. Oh, sorry, John, go ahead.
That's all right. I was just going to note that in our firm, for instance, if a client's problems start trending towards what appears to be a criminal inquiry, that's when I tend to get involved. Okay. So everybody out there should think in terms of a continuum when it comes to legal enforcement in any matter. The start of the continuum is a compliance plan. So in a perfect world, you have counsel that helps you make sure that all your marketing agreements are in compliance with the healthcare laws, because as you move along the continuum, there may be let's say a civil investigative demand issued where the government has an inquiry that could lead to civil enforcement, which could result in fines and penalties, but it could also proceed on that continuum to a criminal investigation where there's a grand jury subpoena or there's a search warrant being conducted, and that's certain to lead to a criminal prosecution. So we always want people in your industry to think ahead and get guidance early, but certainly if you ever get a subpoena or investigative demand, or if you ever are subject to a search warrant or know of a grand jury subpoena being issued, you want to contact counsel right away. Next slide. So in the scope of hospice and home health care, all of these all the conduct within that industry will be measured against both criminal and civil statutes if the government is taking a look at it. And another thing that to emphasize is that the same conduct that might result in a criminal health care fraud prosecution could also be a False Claims Act civil investigation. And I can't tell you how many times we've had clients that are subject to a criminal investigation that are asking, well, what about Joe Schmo over there? He did the same thing and his was a civil case. Why is that? Well, there's no magic answer to that. It's whatever the government happens to be thinking at the time. So that's why we really want you to be vigilant. Think ahead. Make sure your marketing agreements are reviewed for legality. Don't be looking at them later to wonder, how was it that I went wrong here? So there's an anti-kickback statute that can be prosecuted criminally, and that's what we're talking about. Something of volume or value is provided as a kickback for a referral rather than it being based on an arm's length arrangement. And that's another thing to emphasize about healthcare. The same conduct that might be perfectly appropriate in another industry where somebody's compensated by volume or value as a salesperson, as a marketer, not so in healthcare. In healthcare, it triggers kickback analysis and potential prosecution. And then the government can always fall back on the criminal healthcare fraud statute, the generic 1347. Healthcare fraud is like any other kind of fraud. It's when there's a misrepresentation or a material omission that leads to a consumer of whatever's being offered to rely on that misrepresentation to then obtain the service, and that service was intended to be provided falsely, and there was actual damages. So that's very generic. You can fit any kind of conduct into healthcare, the healthcare fraud statute when it comes to your industry. And the government, sometimes when they're investigating one of these marketing referral home health care cases, when I'm dealing with a prosecutor, they will oftentimes say, well, we'll let you plead to the anti-kickback statute because the maximum time in prison is only 5 years, because it's 10 years and then can be run consecutively with healthcare fraud. So they think they're offering this great big benefit to somebody who's thinking, yeah, but I was just providing Medicare beneficiaries to this home health care agency. So it can be criminal or civil. You can be the physicians can be subject to Stark statute for self-referrals. The False Claims Act is just like healthcare fraud. It's when a false claim it's when a claim is submitted for payment and there are falsehoods behind that. So, for instance, if a claim is submitted for payment from Medicare and it turns out that there were referrals for those Medicare beneficiaries based on volume or value, the government's going to consider that false. It can be either prosecuted criminally or it can be pursued civilly by the government. Next slide. So we've already talked. I just talked about this somewhat, but the anti-kickback criminal statute prohibits knowingly or willfully soliciting or receiving or offering or paying anything in order to induce a reward for business that's payable under a federal health care program. So it's federal money for the Federal Anti-Kickback Statute. If it's a private insurance company, it's not subject to this kickback statute. It is, however, subject to the healthcare fraud statute that I talked about a minute ago, whether it's whether it's federal or private insurance money. So when it comes to the kickbacks The violations can be 25 to 100,000 per violation. Imprisonment can go up to 10 years. And a big impact, of course, of any time there's a conviction under one of these statutes, you're going to be excluded from Medicare for minimum 5 years and probably longer. If you're licensed, you're going to lose your licensure. And then the government's always going to pursue restitution for whatever was paid. So on top of fines, on top of forfeitures, the government is going to want to claw back whatever money is gained. Next slide. This is just more about the anti-kickback statute. Next slide. So there are safe harbors that will keep somebody out of liability for the anti-kickback statute. And where I see safe harbors in the criminal setting is that people have tried to pigeonhole conduct into one of these safe harbors by basically masquerading the conduct as something else. So there's 25 of these, but let's go to the next slide for some of the common ones. So a personal services agreement is if you are a contractor providing services, marketing services, for instance, as long as the contract is for at least a year and it is paid on a regular basis, not based on volume or value, but just based on, let's say it's an hourly rate, let's say it's a flat rate, and it's not tied to the number of actual referrals of patients, then it can fall under this safe harbor. What we see instead, retroactively, is that the actual agreement is paid by volume, the number of referrals, but the invoices are disguised as if it's paid hourly. So they'll just monkey the invoice to say, oh, I provided this number of hours of work, for this amount of money. Well, then it turns out if you take a closer look, well, they're working 100 hours a day according to that invoice. So the government's going to be wise to it. You can't phony up records to try and meet one of these safe harbors. So again, this goes back to the compliance plan. Make sure that your agreements are fly-spec'd by an attorney. Next slide. Okay, Ashley, you want to talk about the space lease safe harbor?
Yes, absolutely. So we see this specifically for home health and hospice agencies. We see the lease issue come up specifically in connection, with nursing homes and assisted living facilities, et cetera, where they want to come in and have a space for somebody to, do a little marketing and also maybe, have a spot where they can have a home if they're providing services within a nursing home, for example. There are permissible ways to rent space, but they need to fall within the safe harbor so that, a government entity coming in to look at this doesn't say you're just paying this money for this alleged space in order to get referrals. So if you are going to rent space, for example, from a nursing home, and there needs to be a written agreement that's signed by both the parties. It needs to cover the specifics of all of the premises that are being leased. Any part-time lease specificities need to be down there as well. So if there's a specific schedule, that needs to be included. The term of the lease needs to be for at least 1 year. The aggregate rent must be set in advance. It has to be consistent with fair market value. That is a key term here for a lot of the anti-kickback safe harbors. It needs to be fair market value in an arm length transaction and cannot be determined in a way that takes into account, again, the volume or value of referrals or any business that's otherwise generated between the parties. So that is a very important and critical component component of these types of agreements. The services that are being performed under the agreement do not involve the counseling or promotion of a business arrangement or other activity that could be considered to violate state or federal law. And the aggregate space rented does not exceed that which is reasonably necessary to accomplish the commercially reasonable business purpose of the rental. So, you know, if you're just renting that space for a single person to utilize during the day, you know, it would seem to, you know, you would need to have a space that you're renting that is appropriate for that single person. So, you know, you're not renting an entire floor, for example, for a single person. So the space that's being rented needs to be appropriate for the purpose of the lease and the services that are, you know, being performed under that lease by the company that is entering into the lease agreement. So again, if this is something that you want to pursue, you need to work with experienced counsel to help you get a compliant lease agreement in place. You need to consider what fair market value would be for that space to ensure that you don't run into an issue. This is something that the government regularly looks at, something that we see requested in, you know, for example, in a civil investigative demand. So it's something that you really need to take into account and make sure you have counsel prepare these before you enter into an agreement. Don't, you know, have an attorney come look at it after you've already been doing the conduct for 6 months. I mean, it's always better to have somebody look at it if you've never had somebody look at it, but the best practice is to do it in advance, talk to the attorney, get an attorney to work on it before you ever execute a lease. Next slide. John, I think you were going to cover this one.
All right, with the employment safe harbor, if somebody is an employee of a company, they just work for a set rate, and they're the one who's going out doing the marketing, that's a safe harbor. Because if somebody's an employee, they're just paid their regular compensation, and they're not paid based on value or volume. And there's some easy measures about whether somebody's an employee. You know, are they paid a salary? Are they paid hourly? Are they working the same number of hours per week? It's not fluctuating based, you know, to try and make it look like it's hourly when it's actually based on volume. If they have an office at the employer's location, if they are subject to the employer's direction, they're not independent. They can't make their own hours. They can't make their own decisions. Their expenses are paid by the employer. There's some very basic things that will indicate whether the safe harbor is actual or whether it's phony. And I want to say one other thing about these marketing agreements, whether what we see frequently, whether we're representing a marketer or whether we're representing a provider. If we're representing a marketer, we're often told that, well, the provider, you know, gave me this agreement and said that the lawyer had reviewed it, so I'm sure it's fine. And if we're representing a provider and they say, well, I got the contract from the marketer who said their attorney had reviewed it and it's fine. And what we frequently see, I'm sorry to say, is that an attorney may have been involved at some point, but it may have been several matters before. And, you know, the person who provides the contract has gone in and modified it to meet the circumstances. And of course, the modification then takes it from a safe harbor into a violation by having an agreement that's based on volume or value. And sure, a lawyer drafted the original, but then changes were made to take it out of a safe harbor that had intentionally been incorporated. So you're much, much better off, instead of relying on somebody saying everything's kosher, my lawyer looked at it, have another lawyer look at it, another healthcare lawyer. Next slide.
All right.
Ashley?
Yes. Thank you, John. So now we're going to talk a little bit about Stark Law. This is a civil statute. I'm sure many of you have heard about Stark Law in the past. For hospice, this does not apply to you. It only applies to home health agencies. And STARK specifically applies to physicians. So we're really looking here at physician financial relationships. So specifically for home health agencies, that's going to be, your medical directors who are also referring patients to your agency. That's where you could run into a STARK problem. And again, like I said, it doesn't apply to hospice. It applies to certain designated health services, which a home health agency is considered a DHS, as we refer to it here. Potential penalties for STARK violations are up to $15,000 for each claim that submitted a violation of the law, up to $100,000 for each scheme that violates the law, denial of payment for designated health services and refund of the amounts paid, treble damages, and of course exclusion from federal health care programs, which is really, a death knell for a home health agency, or really anybody that's working in the healthcare space. Next slide. Some key terms for STARK. There's a financial relationship, which means compensation, ownership, or investment interests. Again, the most common situation we're looking at here for home health agencies is medical directors. Again, DHS, I just talked about this on the prior slide. Home health is a DHS service. STARK applies to physician financial relationships if that physician will ever refer Medicare patients to a home health agency. So STARK is an issue if they will ever potentially refer a patient. This is a strict liability law, which essentially means either you comply or you don't. If the law applies to your arrangement, then the arrangement must meet a STARK exception. If you do not meet the STARK exceptions and there's a violation, then there's an obligation to refund all payments, and also the potential fines that I discussed on the prior slide. Next slide. So as I mentioned, there are specific exceptions. They're very similar to the anti-kickback safe harbors, actually. The commonly used exceptions are the personal service arrangements. So like John was talking about for anti-kickback, that's going to apply to, a 1099 contractor. The office space lease, there's an equipment lease safe harbor, bona fide employment relationship safe harbors, non-monetary compensation, and investment in a rural provider. The personal service arrangement, that's the one that's likely going to apply to a medical director. The exceptions for that are very similar to the anti-kickback safe harbor and are commonly used to protect these medical director arrangements. Again, what we want to look at there are volume or value. We do not want to be basing our compensation on that. We want to have an agreement that's set out a year in advance. It's in writing. We're paying fair market value, and that, again, we're not paying the physician based on the number of referrals that are coming in. We're actually paying the medical director for services that he's rendering to the agency. He's tracking the amount of time that he's working for those hours. There's invoices, there's timesheets, and that we're complying with our contract. That's going to keep us compliant under STARK law. Next slide. Okay. So Texas also has some specific laws in place. Texas is, I would say pretty aggressive in terms of having its own state laws that apply to healthcare relationships as well. We have a bunch of them on the screen here for you. I'm not going to necessarily go through every single one, but they do have the Texas Solicitation of Patients Act. This is similar to the Federal Anti-Kickback Statute. And permits any arrangement or practice that's permitted by the Federal Anti-Kickback Statute. But interestingly, this applies to all payers and all licensed professions. So a lot of times when we see a state healthcare law, a lot of times it only applies to Medicaid, for example. But here in Texas, this applies to all payers. So it applies to your commercial payers as well, and it applies to all licensed professions. Not just, physicians or home health agencies, designated health services. It applies to everybody. There's a separate Texas physicians solicitation prohibition, which is also similar to the Federal Anti-Kickback Statute, but only applies to physicians. So they've got a separate provision that also applies to physicians from the all payer in all licensed professions. There is another Texas Human Resources Code that is similar to the anti-kickback statute, but applies only to Medicaid and has safe harbors that are similar to those in the Federal Anti-Kickback Statute. There is also the Texas Medicaid Fraud Prevention Act. Many states have laws similar to this it's essentially a state False Claims Act statute that applies to Medicaid. Texas has several self-referral laws that are also similar to the federal Stark law. So there is a provision under the Texas Occupation Code, which governs physician referrals to hospitals if they have financial relationships. And under the Texas Health and Safety Code, there's a provision where physicians cannot refer to home health or hospice if it would violate the Stark law. So again, a lot of these are analogous to the federal provisions that John and I covered. They just cover more payers. They cover Medicaid or they cover commercial as well. And one more is that the Texas commercial bribery law, there isn't a federal equivalent of this law, and there are no safe harbors. Under this law, if a fiduciary commits an offense without the consent of a beneficiary, if they solicit, accept, offer, or confer or agree to accept or confer that the benefit will influence conduct of a fiduciary in relation to a beneficiary. So a physician would be considered a fiduciary under this law, and a violation of this law would be considered a felony. So this is, kind of similar to a kickback where we're, offering something to somebody, and the violation of this law could be considered a felony. It's important as well that we're seeing the government use the Travel Act to enforce state laws too. So for example, there's a Forest Park case where kickbacks were being paid to induce referrals to physician-owned hospitals for out-of-network services that violated Texas law. And because they were using the mail or internet or the computer network, they were violating the Travel Act as well. So you can have federal penalties to enforce state laws too under the Travel Act. We are seeing that happen more and more, which can, result in much higher penalties. Next slide. These are some guidelines from the state of Texas specifically on marketing. Texas HHSC issued guidelines for marketing for providers that are enrolled in Texas Medicaid and CHIP programs. Some of the prohibitions that were discussed were unsolicited personal contacts of patients, like direct mail or email, in phone or in person. It is okay to market, generally on the television or radio or newspaper, but it's those specific personal contacts that are prohibited. You cannot offer inducements or giveaways of more than $10 in value. Offering gifts or inducements that are designed to influence an individual's choice of provider, similar to the prior prohibition. They don't want you to offer something that would influence somebody to choose your agency over another one. Some of the guidelines contain recommended checklists for providers to review marketing materials. So there's some resources there where you can go and look at the guidelines and try to make sure that your marketing practices are compliant. You are permitted to submit marketing materials to HHSC for review and approval. A decision is generally issued within 30 days. I would generally advise that if you're going to reach out to HHSC for approval, that you work with a healthcare attorney before you make a submission to HHSC. Next slide. This is a sample of the review and checklist questions that are available from the state of Texas. So just some examples here. Does the marketing material include a general statement or list all of the insurances accepted rather than listing only Medicaid? If yes, then it meets the requirements. So you need to list all of the insurances that you accept, not just we accept Medicaid. If you're sending marketing materials to everyone within a zip code, then that's fine, but you can't just send them to specific individuals or, individuals who you believe are meet, the requirements for Medicaid or who are over the age of, a certain age for Medicare, you need to make sure that you're marketing to everybody. If the marketing material needs to be at or below a 6th grade reading level, that meets the marketing requirements. If it includes a giveaway valued at $10 or more, then that is prohibited, so that would be problematic. Next slide. So now I'm going to talk about some interpretive guidance that we've seen issued from, you can go to the next slide, from Federal OIG, HHS OIG. The OIG has issued numerous guidance documents on implementing compliance programs in various healthcare fields. We have them here listed for you. Dating back to 1995, there was an OIG special fraud alert for home health fraud. There's just been years and years of guidance being issued by OIG with guidance that still is very useful, applicable things that you should know about. And we're going to try to review some of those for y'all. So go ahead to the next slide. So first, we're going to talk about some home health guidance. Next slide. So this is that first fraud alert that came out in August of 1995. It was discussing home health agencies offering kickbacks to physicians, beneficiaries, hospitals, and rest homes in return for a referral. So again, this is conduct that OIG has been looking at for years and years and years. So this is nothing new, but we still see agencies violating these provisions all the time. So it's so important to make sure your practices are compliant. So the fraud alert specified that providing hospitals with discharge planners, home care coordinators, or home care liaisons in order to induce referrals is problematic. You cannot provide free services such as 24-hour nursing coverage to retirement homes or adult congregate living facilities in return for home health referrals. You cannot subcontract with retirement homes or adult congregate living facilities for the provision of home health services to induce the facility to make referrals to the agency. Really the theme here is that you cannot, provide free services to a nursing facility in order to induce referrals. That's prohibited. You can't pressure physicians in order to order unnecessary personal care services by telling them that their patients were requesting the services and that they would refer those patients to other physicians unless they ordered them. That's prohibited as well. And again, this is dating back to 1995. Next slide. This is some compliance program guidance that was issued back in 1998. I can say that I've talked to a number of home health agencies who still today do not have a compliance plan in place. If you do not have a compliance plan in place, it is critically important to have one. You're required by Texas Medicaid, if you're a Texas Medicaid provider, to have one in place. You actually agreed that you have one when you signed on to be a Texas Medicaid provider. So please ensure that you have one. The compliance guidance that was issued for home health agencies in 1998 is still a very, very useful tool. I'm going to talk about a couple of the risk areas that were outlined, which include home health agency incentives to actual or potential referral sources like physicians, hospitals, or patients. Some examples are the home health agency paying a fee to the physician for each plan of care that's being certified, providing nursing or administrative services for free or below fair market value to physicians, hospitals, or other potential referral sources, or providing a salary to a referring physician for services either not rendered or in excess of fair market value for the services rendered. That'd be your medical director example right there. Services provided to patients who reside in assisted living facilities. Space rental is becoming a problem here, and that needs to meet the safe harbor provisions, or providing services that are otherwise covered under a resident contract or required under state licensure by the ALF. And then again, compensation programs that offer incentives for the number of visits performed and the revenue generated. Next slide. A few more pieces from the guidance on home health policies for compliance. All of the agency's contracts and arrangements with actual or potential referral sources need to be reviewed carefully for compliance and to ensure that they comply with all applicable statutes and regulations. The agency should not be submitting claims for patients who are referred to the agency pursuant to contracts or financial arrangements that were designed to violate the Anti-Kickback Statute, and that you're not offering gifts or free services or other incentives to patients, relatives of patients, physicians, nursing facilities, etc., who would be potential referral sources in order to induce referrals. Next slide. This is an alert that came out in 2016 on conduct involving home health agencies and physicians. OIG found some violations in a study of home health agencies. Specifically, there were criminal convictions and settlements that were discussed, which included making and accepting payment for patient referrals, falsely certifying patients as homebound, and payments for referring or soliciting Medicare and Medicaid patients, sometimes involving payments to physicians disguised as payments for serving as medical director. So again, major issue there that you need to be aware of for your medical director agreements. Next slide. Okay, now for some hospice guidance. Go ahead, Gio. There was a fraud alert from the OIG for nursing home arrangements with hospices dating back to 1998. So again, we're going pretty far back that this has been on OIG's radar, and it is still an issue today. The OIG outlined that it has observed instances of kickbacks between hospices and nursing homes, specifically payments by hospices to nursing homes for room and board being provided to a Medicaid hospice patient. That should not exceed what the nursing home otherwise would have received if the patient had not been enrolled in hospice. Any other payments have to represent fair market value of any additional services actually provided to the patient that are not included in the Medicaid daily rate. Some specific practices which are generally suspected to involve kickbacks include a hospice offering free goods or below fair market value goods in order to induce referrals. Again, room and board arrangements that are in excess of what the nursing home would have received directly from Medicaid if the patient wasn't enrolled in hospice. A hospice paying amounts to the nursing home for additional services that Medicaid considers to be included in room and board. Reciprocal referral arrangements, obviously, you know, hospice to nursing home in exchange for nursing home to hospice, that's considered inappropriate. Hospice providing free care to nursing home patients for whom the nursing home is receiving Medicare payments under a skilled nursing facility benefit. There is an exception here that after the patient exhausts the skilled nursing facility benefit, that the patient will receive hospice services from the hospice. And again, the hospice providing staff at its expense to the nursing home to perform duties that would otherwise be performed at the nursing home. That's a benefit to the nursing home. That's considered a kickback. Next slide. Compliance program guidance for hospices. Again, you need to make sure you have a compliance program in place. The guidance from HHS OIG goes back to 1999, but is still very helpful. It identifies several risk areas, such as incentives to referral sources like physicians and nursing homes. So for example, paying a fee for each terminal illness certification, or providing nursing, administrative, or other services to physicians or nursing homes or other potential referral sources. And again, that excessive room and board payment issue. Providing hospice services in a nursing home without a finalized written agreement. You need to have a written agreement with a nursing home under which the hospice is taking full responsibility for the management of hospice care, and the facility agrees to provide room and board. Improper patient solicitation activities, such as patient charting. For example, reviewing patient records in an assisted living facility without the patient's approval, with essentially the goal of mining that resident population for hospice services. And sales commissions based on the length of stay in a hospice. This may cause recruitment of long stay patients whose stays may be ineligible for hospice benefits. Next slide. Some guidance on hospice policies that should be in place. All of the hospice contracts and arrangements with actual or potential referral sources are reviewed carefully for compliance with all applicable statutes and regulations. That you are not submitting or causing to be submitted claims for patients who are referred by financial arrangements that would violate the Anti-Kickback Statute, and that you're not providing free gifts or free services. to patients or relatives of patients or other potential referral sources. Next slide. Some other guidance on things that may constitute a potential kickback. Offering free or below fair market value goods to induce nursing homes to refer patients to the hospice. Again, the room and board issue. And again, I've stated this before, paying above fair market value for non-core services that Medicaid does not consider to be included in its room and board. Next slide. Okay, and a fraud alert on physician compensation arrangements that may result in liability. This is from 2015. There was a discussion in this document of 12 individual physicians with a focus on medical director payments for hospice. The compensation relationships that were discussed in this fraud alert specifically included payments that varied with the volume or value of referrals and did not reflect fair market value for the services performed. Non-performances by the physicians for the services they were supposed to be rendering under a contract, and payment of salaries of physicians' office staff by the hospice. Next slide. Okay, some tips for best practices here. It's important that you educate yourself, do what you're doing today, listen to webinars, make sure you're up to date on current safe harbors, current regulations, changes in law, so that you know what the rules are. Retain healthcare counsel. Our managing member, Robert Lyles, always likes to say, everything you say as a healthcare provider is evidence in an investigation. Anything an attorney says is an argument. So it's very important that you retain counsel. If you do receive some sort of request for documentation from a government entity, retain counsel, have the attorney correspond with the government entity or investigator on your behalf. If you do not have a compliance plan, get one. If you're a Medicaid provider in Texas, you have agreed that you have one in place. So very important that you have an effective compliance plan in place and that you actually follow that compliance plan. Don't just stick it on a shelf and never look at it. Some best practices for physician relationships: ensure that every relationship with a physician is documented and reviewed by a healthcare attorney. Make sure you're paying fair market value for services being provided by your marketers, by your physicians that are being medical directors. If you are leasing space, that is fair market value as well. Medical directors should be compensated solely for clinical and administrative services. There should not be a link to referrals or admissions. Physicians should be documenting their time, keeping track of the amount of time that they work and what they're doing during that time. For their medical director services, that's a critical component in an investigation. If you have that documentation, that is great. If you do not, you need to start requiring that your physicians track their time and what they're doing during that time for their medical director agreements and what they're being paid. Review your medical director invoices to ensure that the services provided and the hours worked would be considered reasonable. Train your medical directors on eligibility criteria, Medicare definitions, and compliance, and monitor your relationships with outside referring physicians, your officers, and your marketers as a part of your compliance program. Take a look, see what's going on. Are you receiving 80% of your referrals from one location? That could be a big red flag in an investigation. Next slide. Make sure you are screening your physician referral sources and medical directors monthly for exclusions. We have the exclusion databases on the screen. If you are receiving a referral from somebody who's excluded, that taints the entire claim process. All of those claims that were referred by that provider are invalid and need to be returned to Medicare. So make sure you're screening those providers and ensuring that they're not actually excluded, so that you're not liable for returning that money to Medicare. Next slide. Marketing staff. If you are paying your marketers as employees, make sure they're actually employees. Consider the IRS definition of an employee, which Don talked about earlier. We've got some of the examples here. I know we're close to the end of time, but behavioral control, financial control, and the type of relationship. Evaluate your compensation plans for marketing employees. Compensation should not be based on the number of admissions or the length of stay. Even though you have a bona fide employment safe harbor exception, Note that many cases involving employees are still problematic. Make sure that, you know, you're not based, there isn't a way to tie that employment relationship or the payment back to varying based on the volume or value of referrals. Incentive payments should not be based on individual economic production. Compensation for marketing by independent contractors should meet the personal services safe harbor that John discussed earlier. And that should, of course, be at fair market value and not based on the volume or volume of referrals. It should be a fixed fee determined in advance. Next slide. A little bit more for marketing staff. Separate the marketing function from the intake and admissions function. Intake and admissions personnel should not receive bonuses based on new patients admitted. Stay away from quotas for admissions. Don't fire people for failure to meet goals. Beware of an excessive focus on numbers and revenue. Make sure you're checking your referral patterns. Unless you're in a rural or underserved area, it's really, you should really try to avoid having more than about 20% of your referrals coming from any one physician. Train your marketers and admissions and recertification personnel on eligibility requirements and compliance, and make sure you're monitoring the marketing practices of your independent contractors as well as your employees and their relationships with their referral sources. You are the ones that are being paid by the federal government. You're going to be liable for the conduct of those contractors and how they're getting those referrals in. Next slide. And please avoid offering free or discounted services to other healthcare providers or facilities in connection with home health or hospice patients. And again, I know we've talked about it a lot today, but this is really important for hospice relationships with nursing facilities. Next slide. Facility relationships. Document any relationships between a home health agency or hospice and any facility. Make sure they're compliantly structured, work with an attorney. They're written, they're signed. They're for a year of time, and that they are for fair market value. Next slide. When in doubt, always ask a healthcare attorney for assistance in creating these agreements. Ask if these practices are compliant. It's so much better to find out about an issue on your own than to just be notified of an investigation. So work with experienced healthcare counsel and putting these agreements in place and designing your marketing practices so that you can proceed, knowing that you are trying your best to be compliant with the various applicable laws and regulations. Next slide.
Ashley, I know we're out of time. I wanted to emphasize a few things that we covered. That is, if you get an audit, you're better off contacting an attorney, but at least that's an inquiry by an administrative agency. If you get something like a civil investigative demand or a subpoena, anything from a lawyer about records or interrogatories, you really need to contact counsel. If you get, if you hear of a grand jury subpoena or receive a grand jury subpoena, or if you become subject to a search warrant, that's already risen to a criminal level. You must seek counsel right away. If you have any agreements, whether it's a marketing agreement, whether it's a medical director agreement, and it hasn't been reviewed by a lawyer that you're much better off getting that reviewed. Make sure that you're compliant. If you do a compliance plan, it's going to cover all those things. That's my summary.
Thank you, John. And John and my contact information is on the screen here. If you have any questions, please don't hesitate to reach out to us. Gio, did we have any questions from anybody that's on the webinar today?
Yeah, there's only one. It says, can an employee be salary plus commission based?
There are ways. If you have a bona fide employee, you have a little bit more leeway in how you're paying them. But again, you need to make sure you're working with healthcare counsel to design that employment arrangement to make sure it's compliant. And if you are going to pay some sort of bonus, you need to make sure that that is a bona fide employment arrangement. We've got healthcare, we've got vacation time. They're meeting all of the bona fide employee factors for an IRS definition of an employee.
But that's an example of where if you meet all of those criteria and there happens to be a commission on top of a salary, then that's going to be in the safe harbor. But it's really going to turn on whether you meet all of the factors of a bona fide employee agreement.
That's right.
There's one more that just came in. So how are charitable donations to charitable organizations on behalf of those persons who referred to provider perceived? Private pay, it says, and then in quota it says private pay clients, question mark.
So again, there is an all payer statute in Texas, so we want to be careful about that. I mean, a legitimate charitable donation, I don't think that would necessarily be problematic, but if it's a charitable donation to somebody that you're receiving a large number of referrals from, that could still be considered a violation.
I think that's it. So that concludes today's webinar. Thank you for joining us, and thank you to our speakers, Ashley Morgan and John Pierce. Everyone from today's webinar will receive a copy of the presentation tomorrow via email. And if you have any further questions about today's discussion or another healthcare law issue, please feel free to reach out to John and Ashley Morgan's emails on top, or reach us directly at Lowell's Parker. So have a good Wednesday and take care.
Thanks.
Thank you, everyone.